Shall I file my mandamus action when my priority date becomes current? I'm Sam Shihab.
I'm Brian Burke.
And when we come back, we're going to be talking to you about options you have because of extensive and unreasonable government delays. Good evening, everybody. My name is Sam Shihab.
Again, I'm Brian Burke.
And we're from the law firm of Sam Shihab and Associates. We are here at 6 o'clock every Monday to spend some time with the community to discuss pressing immigration issues. We are a law firm. We practice immigration law throughout the U.S. and all over the world. And today is going to be employment immigration law. And shall I file my mandamus action when my priority date becomes current? Brian, I want to put you on the spot.
Okay.
Yes or no?
I'm a pretty conservative guy, Sam.
No? Yes or no?
I'm also a long-winded guy, but I favor it at this point. I've talked with people, over the last, it's essentially 2 years since October 2020 when all these green cards were filed. And, people have asked, my personal opinion, and reasonable personal opinions vary, of when's the right time. And I think that a court is willing to give a lot of deference to a massive government agency, especially during a pandemic, in terms of, their processing times, saying, oh, we'll take care of it, we're getting to these things. But, this is going to be a case of, fool me twice, shame on me. Last year, USCIS wasted 60,000 green cards. And this year, USCIS, there's going to be green cards. We already know green cards unapproved for people who had current priority dates. And, raise your hand out there for the benefit of yourself if you know somebody who had a priority date after you that got a green card. Yeah. And those are the sort of things that I think a judge might reasonably, if I'm the lawyer who's writing this, I go, all right, this one would be fun to write because I'd like to hear their response to this one.
I agree. I would say yes for me as well. I feel that this is, number one, mandamus action is not new to the government. The government has been sued in mandamus probably, I don't know, I'm sure over 20,000 times over. And it's not only adjustment, it's not only delays in employment-based immigration, delays in family immigration, delays in consulate action. Mandamus action has always been the remedy in which you go to the court and say, let the government do its job. We're not asking for the government to approve the case, we're asking for the government to decide the case. Yeah. And that's what a mandamus action is. The judge does not look at the merits of the case. The judge looks at whether or not the government should act by now. And for anybody who have filed their green card 10 years ago, right? Mm-hmm. And it took a decade long to get to the point in which the green card should be considered, and then they don't.
Yeah.
They skip the line.
Yeah, well, I mean, it's all, for me, again, it's all about the story, So, I mean, we were talking about, it's the fool me twice, shame thing, but I mean, that's just for the last 2 years. It's, this person has been waiting, 10 years to get a green card. The time finally comes, and, how much longer are you going to make somebody wait? 3 years?
And if the priority date retrogresses again, next time around.
Yeah, and there's two sides of this. We're still optimistic on the visa bulletin front, talking, we think that there's really room. So in case nobody's aware, the visa bulletin for October is going to retrogress about 2.5 years. But Sam and I are still talking, well, it seems that they're going to have the visa bandwidth to keep on moving it forward. But USCIS said themselves in response to a lawsuit recently, maybe it'll go forward, maybe it'll keep on, maybe it'll go backwards. Right. And so I don't think anybody has any reason to trust USCIS on this for sure.
So the question that we get all the time, would they retaliate?
Yeah.
if I file a mandamus action.
Yeah.
And what's the short answer?
No. I call it, the beautiful thing about our civil service is that, while sometimes it's grossly inefficient, however, it is fundamentally honest in that, there's probably not a government officer out there going, I hate you, I'm going to slow your case down. It's just more of a, they largely do their job competently, but that takes time.
Yeah.
You hit a point where you cannot give deference to the government saying, we'll take care of you.
Yeah, I've been around mandamus as far back as 20 years. And we filed them back then when there were delays in naturalization cases, when there's delays in any other approvals, we filed mandamus. And we dealt with the court. And in most cases I've dealt with, got resolved reasonably quickly, and that's no guarantee that your case will be resolved in any speed or any timeline. Every case stands on its own. You can file a writ of mandamus in one court, and you can find the exact writ of mandamus in another court and get completely different attitude and results.
Yeah,
depends on the judge, depends on the court, But the common theme around it is when the case is delayed for as long as it's delayed, a mandamus will never negatively impact you, and you will never deal with retaliation. I have never seen it.
Yeah, again, fundamentally, writ of mandamus is not going to make a bad case good or a good case bad. You cannot force the government. That's not what the court does. It's basically the court asks the question, hey, is the government required to do something, and are they doing it in a reasonable amount of time, essentially?
And the reality of the matter is, in the court system in America, forget about the mandamus, stepping out of it, more than 95%, and people say 98% of cases settle out of court.
Yeah.
2 to 3% of cases get tried. Why? Because trying a case is time-consuming, not only for both parties, but also for the judge's time. A case in trial is a week's time, 3 days, 2 days, 4 days, and the judge has to listen to the whole thing and analyze and write an opinion, and nobody wants to do that, especially the judge.
Yeah.
He or she, they do not want you to come in with a mandamus action where it's clear it could be resolved. And that's advantage plaintiffs, in this case. Judge doesn't want to see it. We don't want to do it, but we're forced to do it. We have a story to tell.
Yeah, I mean, ultimately, that's what the case is fundamentally about. There's all sorts of legal standards, but basically, it's the government will say, no, we're taking care of this. We're in a reasonable time frame, and it's somebody filing for mandamus right now is saying, no, it's not. Yeah.
So processing times, a lot of people say, well, let's go through what the what the law is.
A little bit nuts and bolts.
So people have an idea, although I think most people want to know, obviously everybody wants to know how much this thing costs. Well, mandamus is not the cheapest process in the world, and you need to talk to the lawyer one-on-one to have that question answered. This is the right place or forum for it. Here we are talking about the application for mandamus or the writ for mandamus or of mandamus that you will be filing in court. So over that one, that's a big question people want to ask. It's not the cheapest process. There's no retaliation. And the truth of the matter is, other than the money you pay for the cost of the mandamus, there is zero negative impact or downside to filing a mandamus. I just don't see any downside.
Well, I'll play Mr. Rainy Day. Obviously, there's a lot of cases that get resolved quickly. However, if by chance you find the government attorney that wants to, fight you on a case, in theory they want.
But it doesn't delay anything.
Yeah, agree. Yeah.
There's no impact. There's no delay whatsoever.
Oh yeah, no. On your case, no. It doesn't impact.
There's zero delay. There's zero negative impact.
The agency keeps on doing what it's doing while your court case is pending, and a lot of, as we discussed, a lot of mandamus case actions will end up being rendered moot by the agency making a decision, for sure.
And as a matter of fact, there was this recent class action EAD case which was dismissed, and you know why it was dismissed? because each and every plaintiff, their EAD was approved magically.
Yeah.
So the case was dismissed because all the plaintiffs that created the class are no longer couldn't be plaintiffs.
It's a great way to make a court case
go away by approving all the EADs. Yeah. So I mean, everything is upside. I mean, aside from the cost, there is no downside for filing a mandamus, and substantial, good, strong likelihood for an upside in your case.
Let's talk about what the sort of the standards are here. So basically, there's a statute that provides for writs of mandamus, and it's a little bit of in lawyer shorthand here, but one, the plaintiff has to have a clear right to the relief requested, and that's a decision on my case, and it's pretty well established that you have a right to do a decision on your adjustment of status. That you can't just file one and they say, no, we're never going to decide this.
Well, the right is created simply by paying the fee.
Yeah.
They cashed your check long time ago. Yeah. They took that money long time ago. Yeah. So there is an identifiable right. Otherwise, they would not have taken your money.
Yeah. And the other side of this is, it's kind of actually sometimes grouped together with number one, the defendant has to have a clear, non-discretionary duty to perform the act. And again, that's adjudicated the case. And for green card cases, the government it's very clear that they can't just take your money and say, they have to approve it or deny it. You can't just let it sit in limbo forever.
And there is clear law on this with decisions back in 2002 where the court said an adjustment of status, there's a clear non-discretionary duty by USCIS to approve your case.
Yeah, so really where the magic sort of lies and the devilish detail is in the mandamus action is, no other adequate remedy being available. Because for me, I guess there's also a discretionary factor in this as well. But, what other options do you have? A court might consider, have you done everything else you can in order to get this approved? And the things we think about to make the process move faster, in immigration processes are things like expedite requests or congressional inquiries or service or expedite requests. Service requests, those might, arguably I guess you should be doing those, but
these are not remedies.
Yeah, and for the fact that they keep on extending the service request time, which such that most people with October 2020 green cards filed, they can't put in service requests anymore. They keep on extending the processing time. Congressmen, that's outside of the administrative procedure. And expedite requests, you probably don't meet those requirements because they're pretty clear requirements.
Well, I mean, expedited request is a completely different legal standard, and you do not have to meet an expedited request for USCIS to have a non-discretionary duty to perform their function. Yeah. And the other stuff you mentioned, these are not part of the process.
I
These
agree.
are not a remedy.
Yeah, I mean, I think if I was writing a complaint, I would like to be able to say I did them, but it would basically, you want to, the way the law works is essentially, you want to tell the court that you exhausted all other remedies that you had of you. And I would agree that those aren't necessarily required ones, but I think I like the idea of them.
Where do you place on that list the fact that the government have approved cases ahead of your plaintiff?
Well, on that list, it says there, and I'll put us back on the main screen, it says, even if all the elements are found for a mandamus,
they are on the main screen.
The court has a discretion to grant or deny, and I interpret that as essentially the delay must merit the court to force action. So that's kind of where that falls. It's basically, if you demonstrate that they are so far behind, so far messed up that you cannot tolerate it anymore, that's where that's where really it all falls into, in my book.
Honestly, I mean, these are what allows you to bring a writ of mandamus.
Yeah, I agree.
But it doesn't mean that these are the elements that are necessary for you to win a mandamus.
Yeah.
What you need to do to win a mandamus is to demonstrate unreasonableness, unreasonable delay. And I think that goes into the element of unreasonable delay that my plaintiff has been unreasonably delayed simply because the approved case is ahead of him.
Yeah, I mean, I think the government's perpetual counter-argument to that will be, but you're still within normal processing times, and I think their processing times arguments sort of fall apart because they keep on extending their processing times. I mean, they have some compelling things to say in terms of, we're in the middle of a pandemic.
That's not the standard of reasonableness. Is their processing time, because basically it's a self-fulfilling prophecy, right?
I agree. I agree with that.
The slower they can get for everybody, the less mandamus action they can bring, and therefore, what incentive do they have to do their job? Because you know what?
Yeah.
If we are less efficient, we get sued less.
Yeah.
That's basically what you're telling.
Agreed.
What you're telling the court, and the court is not going to buy a processing time as a standard.
I think there's a reason why you don't file a mandamus 1 day after your case is filed, because you don't. But when it hits
not because
years,
it's not within processing time. I think because it's clearly not unreasonable for the government to take more than 1 day.
Yeah, exactly. I always say, for these cases, more time equals better case, because it's every day you tick off is, it's
more egregious, more
yeah.
unreasonable the government becomes.
Yeah.
And the more unreasonable they are, the better case you have, obviously.
Yeah, and going back to the factors on unreasonableness, they can consider, what it does, to the individual. Because if you write a mandamus case, you're going to basically tell somebody's story. And, basically somebody's been in the United States contributing to the country for a decade, and, they finally got the opportunity. It's been 2 years, and what does it do to them? It puts their immigration status in limbo. Basically, they're not, they have problems, they're left in a lesser position in terms of travel, in terms of working. All these things are the things you sort of,
And some people are financially impacted, and those financially impacted, definitely it affects them. I mean, for example, a case in which your children will not be permanent residents and therefore will be not able to take advantage of certain, perhaps, financial aid in college.
You're looking down the road. I mean, there's a future. It's, I'm going to be delayed in becoming a permanent resident. All the benefits come with that. I'm going to be delayed in citizenship. I've been eligible for years. And you guys, think of it. If they approve your adjustment of status case in, 3 months, you'd be a good chunk of the way towards U.S. citizenship if you so desire right now. And that's the sort of thing where they may not consider that very compelling, but that's the sort of thing that drives me mad, just knowing that there are people out there who, if they were processing green cards at rates like they were, years ago, people could be on their way to U.S. citizenship right now.
So if the visa bulletin is published today, would you file a mandamus first day?
I'd say you're within your rights to. That's for sure. So basically, what you're hinting at, Sam, I think, is that your priority date should be current. Final action current on the visa bulletin.
It has to be approvable.
Yeah.
I mean, a mandamus action when your case could not be approved is a very easy motion to dismiss.
Yeah.
On opposing party.
I still have. I agree with you, but I still have beef on that, because my response to that is my date was current months ago, and you guys didn't approve me. I know the court will agree with on that one, and they won't take my position, but that's the upsetting part. That's what gets underneath my skin, is that you can't even file a court case right now.
I think is, are you entitled to the benefits?
Yeah.
A clear right to the relief requested. You fail on that one.
Yeah, I know. It just drives me mad, because no, I'm sorry. I should have gotten this benefit months ago, but I didn't, because you did these things out of order, for example.
Yes.
Yeah.
And mandamus act is not a complicated thing. Obviously it requires a competent lawyer. There's a lot of lawyers that know how to do it. It's not like a unique science, a secret recipe, or a secret sauce. It really isn't. It's like filing an adjustment of status. It requires knowledge of the law and knowledge of the court system, and you should be able to file a mandamus action through your attorney, a knowledgeable attorney, and these are filed all the time across the spectrum of immigration cases.
Oh, yeah.
For as long and as many years I remember. This is not something brand new or unique to employment adjustment delays. This is extremely known. If you type USCIS mandamus cases, you're going to find pages and pages of reports on prior mandamus cases filed.
Yeah. I mean, fundamentally for me, Sam, there's you can trust USCIS to process your case again, or you could, not trust them and try to twist their arm.
I don't think it has anything to do with trust. I think it has. You should never trust the USCIS. They should never trust the government. I mean, our legal system in this country is based on not trusting the government.
Yeah.
Right.
Yeah.
I mean, the right to bear arms is founded on the fact that you should never trust the government 100%. And that is ingrained in our way of government, in our way we live our life here in this country. Don't trust the government. If the government tells you, trust me, say not. I don't trust you. I got to do what I got to do to make sure that I'm protected through the process.
Yeah.
Yeah. Do you want to go through anything else on this?
Well,
What's likely to happen?
Yeah, that's there's the nobody can give you, nobody knows what's going to happen going into a particular case. Obviously, if you have a more compelling story, a more sadder, more compelling story, because somebody on the other end is going to have to read it. Maybe you fare better. But basically, procedurally, a lot of cases, we have filed mandamus cases in the past, and the government attorney could eventually, pick up the phone and say, okay, how do we resolve this thing? And the answer is going to be respectfully, if you could pick up the phone, and there's one way to resolve this. It's have USCIS make a decision on this case. Yeah. But it is always possible. It is a court case, like any other. And they can choose to litigate the issue to really kind of any court case you file is going to start with a complaint against the government saying here's what they've done wrong, and one can hope, and it's often proven to be the case, that the government will say, I don't want to even have to respond to this. I'm going to pick up the phone and basically ask USCIS to look at this and resolve it.
Bottom line is this, Brian. If you talk to attorneys that filed mandamus, they will tell you that most of the cases I've handled have been resolved.
Yeah.
And that's because 98% of all cases, not only mandamus, are resolved without trial in this country. Because nobody wants, no judge wants to sit down for 2 days to argue whether a case should be adjudicated. Yeah. And it's just impossible. And therefore, these cases are resolved most of the time. And there's only one way to resolve these cases, Brian, is to adjudicate the case. Because we're not asking for a decision.
You're right. So if in theory, and it's like a court case, the government could in theory try to draw it out, but ultimately you're just marching towards that decision whether the government has been reasonable in that amount of time. And there's things to talk about in a court case, motions and discovery. It's not really a case that requires.
One way to irk a judge is to walk in trying to waste his time on something that the government clearly had to do their job and adjudicate the case.
Yes, I agree with you. But fundamentally, if you put in your complaint that I've been waiting, for two plus years for a decision, I think the judge response is, what kind of work does the court really need to do here? You guys, I can tell you whether it's reasonable. We can spend about a year me telling you whether it's reasonable, or everybody could stop wasting their time
and get it done, and let's move on.
Yeah, it's not definitely not a guarantee, but it's a very reasonable thing to do, because that's if this case gets dragged on, that's the government spending their attorney's time and money and resources, and it's so spending the judge's resources.
It's a reasonable request from the court to request kindly and professionally the government to do their job. That's what it is. When we come back, we'll answer your questions. So this is the time when we take your questions. And just to let you guys know, the advice we give here is a general advice, general nature. No attorney-client relationship is established solely by answering your question, and we advise you to contact a competent immigration lawyer before you make any decision on your case. And then the last thing is, if you have posted questions before we went live on our streaming session, our system we do not pick those up. And we apologize for that, but we're going to start with VJ Singh, I believe.
Yes, sir.
Question.
Let's make it nice and big here, easy to read. Yes. So, hearing that the actual family base spillover into fiscal year 2023 will be around 45K, not 60K. Given this, when can I expect the priority date of April 29th, 13 to be current under EB2? So
that's 15,000 drop, and I obviously, doing the simple math is it's about a half of those, 28.6 plus 28.6. add those up, that was 60% of that 15,000 is impacting the EB to India because the fall across and fall down. So, there is going to be a drop. There's no question. I haven't calculated it because at this point we can keep calculating endlessly.
Yeah.
But that's a good question, and I'm not sure whether that is going to be a final number or not. We'll find out soon here.
Yeah,
when they publish it officially.
The way I view it, April 29th, 2013, that's about a year off from current. We know USCIS has 36,000 EB2 India green cards, more or less close to, in their backlog. This year's allocation was 60,000. I think it's reasonable to believe still that they will have
They have to move forward.
Yeah, there will be an allocation of 36,000 EB2 India green cards this year, meaning I would hope that they can clear out that backlog.
The question is how many duplication between
That's a good point, yeah.
the 25 or 30,000 EB2s and 30,000 EB3s to begin with. We don't have answers to those questions, and how much is the rest of the world numbers will be, nobody knows. So,
so here's a kind of related question. The pending inventory of 39,000 EB2 and 25,000 for EB2, is this pending inventory up to January 2015 dates? So I haven't looked at the EB3 numbers as carefully because I'm just sort of dismal on their prospects, but I believe the more accurate number for EB2 based upon the last thing I saw from USCIS was 36,000. So basically, I think what this question asks, Sam, is basically, does this account for everybody who has a priority date up to January 2015?
It's not clarified in the court action, but my interpretation was yes, it does.
I guess yeah. Well, for me, it's simple: is who didn't file a green card when their priority date is current.
I'm not sure when you use the word inventory. I'm not sure you create a distinction between inventory on a certain date or not. We got in the warehouses for India that much number and that much number.
Yeah.
And we have to clear those before we can move forward.
Yeah, I guess maybe the way I interpret this is like, hey, are there many more people out there who haven't filed? And like my answer is, a handful. We have people, for example, who were outside the United States or weren't able to file for adjustment, and thereby they're going to be doing consular processing. But I think most people who get that deep in the employment-based process, stay in the United States until it reaches its end.
Remember, that lawsuit was dealing with approving cases, right? And it was December 2014, EB2, when the priority date lasts the most.
Yeah, that's the furthest final action date we've got.
Forward movement.
Yeah.
And the question is, does that include up to January 2015? If it does, then it's going to have to be.
I understand. I understand your alternative in take on this. Yeah.
And if it does, then it's going to have to be in the EB3 because EB2 never went beyond December 2014, anyways.
Yeah. So you're right.
So to answer that question here,
it can.
If it does, it's not going to affect the EB2 numbers. It's going to affect the EB3 numbers.
Yeah. Because I guess
we don't know. I
guess the point you're making, and this is we're in the nobody can file this. Let's move on, Sam.
Yeah. But we don't know. We really don't know.
Yeah. Let's keep on going. From Sanfax. Go ahead, Sam.
EB3 downgrade 2020. EB2 upgraded in April 2022. 45 status is pending. I'm in EB2 or EB3Q now. If you upgrade it to EB2, I'm assuming with an interfiling and a supplement J, but say supplement J status is pending. Am I in EB2 or in EB3? If you filed if you've interfiled to an EB2, you have to assume you're in EB2.
Yeah, it's funny. I attended an interview recently where the officer said, "Hey, what category do you want to be in? I have you in EB2 and EB3 and EB2." Which is actually, it's funny, it's kind of the most substantive knowledge on I-140 employment-based green cards I've heard from a USCIS officer during an interview. The answer was, yeah, EB2, I want to be in EB2.
Whichever they give me the green card now.
Yeah. So I don't.
Which one do you have? Do you have a number for which one? Do you have a number? That's the one I want to be in.
Yeah,
I don't care.
Yeah, but I'm with you. I think if you sent it in, the interfiling request, I presume you're being considered an EB2.
Yeah.
They can't just tell you. They can deny interfiling requests, but not without good reason.
We've never, especially with the way they were encouraging it.
Yeah, ultimately, we're talking about their delays are problematic, but ultimately they're not acting in bad faith. They're not trying to keep you in a category that's going to keep you from getting a green card.
That's a good question here coming up, Brian. Take that one.
Yeah, so from Sajanya, I just found my H-4 EAD is lost when trying to fill in I-9 verification for a new job. I have a copy of the EAD. Will this work for I-9 verification? Please give some options. So, I-9...
No.
Yeah.
So the answer is no.
Yeah.
It does not work. You must have the card in hand, and also you must be able to present the card, and they must inspect the card.
That's the problem.
So you gotta have a replacement EAD, and you do not have an evidence of employment authorization, unfortunately. I don't see an option. Now, here's the good possible news is with the automatic extension, because the moment you file it, you really are extended. So if you can file for...
If you file it before your EAD expires.
Before expired.
Yeah.
Well, yeah, obviously lost, so I'm hoping that's not expired. And so one trick that you can do is you can file for an extension.
I would want to read the law on that very carefully.
Yes, but I would look into that option.
Yeah.
Definitely with an attorney, because once you have an extension accepted, you're authorized to work.
Yeah. Yeah.
Especially if you can get one-day extension.
No, that's. Yeah.
But you may not be entitled to extension until 120 days before the expiration date.
Yeah. That's the thing. If your EAD is lost, are you in good faith filing an extension? And that's an interesting.
Yes.
It's a thought, and that's the sort of thing where I'd say that's a good thought, and we're going to have to research that for you for a bit, because ultimately, you have to satisfy it to the satisfaction of the employer as well. They're the ones who really process your I-9. So
yes, I agree. Yeah, but if in fact this EAD is about to expire, within 120 days, so
there's no requirement
extension
that you have
is a wonderful
EAD
solution
in hand in order to extend your EAD. That's a good
and you can the receipt notice can be.
No, but the problem is that in order to meet the I-9 requirements based upon an extension, you have to have the
original expired EAD.
Yeah, that's the problem.
Yes. Well, we go full circle, and we couldn't help you.
Yeah.
Sorry.
Yeah, it's kind of the
chicken and egg.
We
went after the chicken. We ended up
in terms of long processing times. That's something they haven't been able to really fix yet. It's the long processing times for H4s and EADs. And I know they're talking about integrating permanent premium processing for that sooner or later, but it's on the agenda.
Yep.
Next.
All right. Hello, sir. My priority is EB2 2005.
2015. Yeah.
2015. Do you think my filing date could be current in fiscal year 2023? So right there on that line of
filing date current. He asked that good question.
Yeah, of course. Wow. Well, with the drop back from 60 to 45,000, I'm becoming a little bit more conservative about that one.
My take is if they use the filing dates like I think they should, I would say it wouldn't blow my mind. I wouldn't be surprised if at some time during late in fiscal year 2023 that date became current.
So the date for filing is going to move when you feel that in the future you're going to be able to get there.
And
but
in
if
theory,
you don't get there,
I'm sorry, Sam.
Yeah,
in theory, if they know the next year's coming with a bunch of visas available, they should move the dates for filing a little bit further to account for the visas coming next year.
Yes. Hi, Sam and Brian. Do we know the distribution of priority date of pending EB3 applications? Do existing pending EB3 applications include applications with priority date beyond 2012?
So,
I don't understand the question. Do you?
So I think this person is talking about the inventory with USCIS, right? The inventory that's out there with USCIS. Should there be dates out there with, is that inventory going to be people with dates beyond, whatever the current priority date on the visa bulletin is? And the answer is yes. It's people who, the current final action date for EB3 India is
April 2012.
April 1st, 2012.
Yes.
Meaning anybody who had pending EB3 cases must be ones where they had a current filing date or final action date at some point. Thereby USCIS took the cases. But they're still with USCIS because they can't be. I guess not all of them, Sam. In theory, it could be people with still current priority dates that just haven't been approved yet. It can be, I have talked to people recently.
So
Sam.
when you get so everybody understands, when you have a priority date, which is April 2012, the government will only adjudicate cases with a priority date prior to the published date.
Yeah.
Which is April 1st. Is the published date, I believe, right?
Yeah, April 1st, 2012.
So up to March of 2012.
Yeah.
Any cases with a priority date of March 2012 and prior will now, next month, in October, will be adjudicated. until the next visa bulletin is published, and then whatever that date is going to be only prior to that published date.
Yeah, that's what
And
they
I think that, yes.
I guess I would say anecdotally, I talked to somebody recently, still has a pending EB2/EB3 I-45 with a 2011 priority date. So I guess not everybody with a still pending EB3 or is necessarily after that date in 2012. Yeah.
Fine.
Hi Sam, Brian, do you see February 2014 EB2 India becoming current in fiscal year 2023? I missed filing last year. So missed filing last year. So again, there's people out there who maybe didn't have the opportunity to file for whatever reason. February 14th, 2022. February 2014.
We believe that the filing date at least is going to have to move to that date.
I think I think that's reasonable to believe that the filing date can come to that.
Yeah. For the 485 application, if the wife does not want to live in the U.S., can husband and kids only file 485 and get green card? Wife want to live in India to support her sister and parents. Well, I will not comment on husband and wife living apart because that's a living apart permanently, potentially.
Yeah.
But the legal answer is yes. And you can always change your mind and do a following to join in the future. And the following join, long time ago, used to have a 1 year limit on it. Now it does not. So you can do a following to join for 3 or 4 years later, as long as you prove, one, that the marriage occurred prior to the receipt of the adjustment status. And the second thing really that you will have to prove is whether or not you have a bona fide marriage.
Yeah, that's a very interesting take on that, because I imagine being at the interview with just the husband and the kids, and I think the question comes, where's the wife? And you're right, if this person applies for that green card through the consulate
future,
later,
they have to be convinced. And there could be special circumstances.
Yeah, again, it's all fact specific, Sam. And I see, if you have good documentation that you're staying there to support, family that need you.
Mom is sick. I want to be with her. I feel like I need to support her.
Bottom line, there's no requirement that anybody immigrate to the United States, but understand that your ability to stay in the United States might be more complicated in the future.
My priority date moved back 2 years. Will USCIS still process my supplement J? So my priority date moved back. What do you mean by that?
I think he means retrogression. I think he means the visa bulletin moved back. Yeah, meaning he's still 2 years from current.
Would they process supplement J? They should process supplement
Certainly.
J. Absolutely.
You're still entitled to the benefits, even though it stinks and dates have retrogressed. You are still entitled to the benefits of a pending I-45, and that includes portability.
So your priority date, AK, has not moved back 2 years. The visa bulletin published priority date has moved back. Your priority date does not change.
Yeah.
It's the date in which your labor certification is filed, or if you filed without labor certification, your I-140 is filed.
Yeah.
I have an interview scheduled. How can I hire you guys to go with me since my case is a little complex? Vera, well, we're honored. Obviously, this forum is not about hiring us, but you can go, if you want to contact our firm, you can go to
our website has
our website. I think Get in Touch, and complete one of those Get in Touch, and then there's a contact us email or something, and we do all the best we can to reply to every email we receive. Thank you, but I just want to emphasize, we're not here.
Yeah.
I mean, we're here. We're lawyers. We make a living representing, but love to hear those compliments. Thank you very much.
Yeah.
Hi Sam, Brian. January 3rd, I'm an Indian national with H-1B, and my wife is Australian national on E3 visa. We are trying to get our visa stamped either in Canada or Australia.
I think it's part one of three. Yes, here we are, 2 or 3. The first time H-1B stamping for me with previous F1, I presume, stamp on my passport. It's the first time E3 stamping for my wife with the previous H4 stamping on her passport. Is there a follow-up? Here we are. Please advise which country would be best for us to get our visa stamped. Does change of status be accepted in Australia and Canada? Interesting question.
Well, the interesting question, and it's a legitimate question, because obviously they're husband and wife. And the consulate must give deference if you are Australian. If the wife is Australian citizen, they must give deference to USCIS, to the husband, to be adjudicated, if the husband is entitled to stay legally in Australia due to being the husband. So the best way to handle this normally is an email to the consulate. Contact the consulate and say, listen, I'm going to be here in Australia on a valid visa. You're going to tell them what visa you will be on. And I would like to come in and set up time for an H-1B stamping for me and E3 for my wife. Would you be able to handle it? And they'll reply.
Yeah, I mean, honestly, third party, going an Indian national going to Australia for stamping would be what they would call third country stamping, right? And it's always discretionary, but you have a compelling reason why you should be in Australia. And they're basically, as long as you're legal, the thing that usually makes those things fail is if you're not legally entitled to be present in Australia and you have a perfectly good reason for being in Australia.
100%.
Yeah.
Yes. All right, jumping on the next one here, Brian.
From Vishal, thanks Sam and Brian for support. Reported date is 25th of April 2014. I got a medical RFE on 4th of September, and I submitted and reached I-693 on 12th of September. Is there any slightest chance of approval? I got EAD AP yesterday.
Yes, there is a slightest chance, but only the slightest chance, because if there's a visa number pulled for you in the file, then that's that. I doubt that there is, but there is a slight chance, but only a slight one.
I think I agree with that.
The fact that they're continuing to adjudicate an interview tells me that there is an anticipation of forward movement.
Yeah.
We don't know.
We don't, but we clearly try to be helpful,
Yes.
So
April 2015, current this year.
Any chance of getting current this year?
For sure, filing date.
I feel pretty good about filing.
Current, possibly,
April 20, that's April 2015.
AB2 India.
Yeah, I think I give you filing dates as long as they accept those filing dates. Yeah.
Yep. Is there any law from Jagan? Is there any law coming for giving green card? Any law coming for giving green? I'm sorry.
Any law coming for giving a green card for those staying more than 7 years, Sam? I think we were just actually emailing about this subject recently.
Yes.
My priority is 8/2015 and got an offer at Big Tech. I will accept it. Will the date move back 18 to 20 months?
So this is the registry.
Yeah.
And it's not coming. It's a proposal in Congress that every year or two they propose one. The last time there was a registry was, I believe, we're talking about 1986.
Yeah.
I believe.
Yeah.
And that's a long time ago. I don't think this country has any appetite for registry right now, giving a lot of discourse. So I just don't see
a congressman or woman whose name escapes me, I can't introduced an updated version of that. We just aren't exactly optimistic on that front.
Yes.
Yeah.
All right, grab the next one, Brian.
Time to start mass litigation, get rich quick. Just kidding.
Well, that's a good question. Mass litigation is time and time again. Well, I mean, when you bundle a lot of cases, it's not in the best interest. A lot of times, I mean, sometimes it is. I know there has been attempts to bundle up mandamus actions recently. And those cases, when you start bundling up these cases and trying to try them as a group lawsuit or one lawsuit, they get infinitely complicated, and judges hate them because they're not common issues between them. Every mandamus stands on its own.
Yeah, it's about your personal factors.
Yeah. So trying to bundle up all these cases is not a good thing. Get rich. I know you're just kidding, but get rich is not what I want, because all of us, you guys listening to this presentation and us here, all of us have worked hard and done well for ourselves, and get rich is not what I want.
I mean, for me, we've talked on and on in this venue about mandamus for the last year, and ultimately, it's for me. I've had conversations with clients, and basically, I've said, it's case plus time equals better chances of mandamus.
I'd rather file an adjustment status and a family case or an H-1B any day over a mandamus, to be honest with you, because it gives positive results and happier client. Mandamus action is usually the client is frustrated and you're trying to do something. When you're successful and you do something, they're very happy, but you're not starting from a happy point.
People ask us, I meant to bring this up at the beginning, but here's what doesn't clearly work. Expedite requests because most people don't qualify. Service inquiries because the government says we can't take them. Congressman inquiries because they'll basically say, you're not a priority, you're not an expedite request. People ask the question, what can I do? And that's what you can do at this point. Will the government, that's really it. It's something you can do, and it's a good thing. Yeah.
When can I see EB2 prior date 2014, April 2015, getting current? Brian, look at your crystal ball.
My crystal ball is apparently quite big, and it is invisible. But I see that. I mean, that has been current before, and if the backlog is mostly what we believe it to be, it seems that can be current again in this year.
My EB2 was approved September 22nd, 2022. My priority date is current. My I-45 is still showing fingerprints obtained, but nothing else. Nebraska Center doesn't have to move to NBC before an approval can happen. Not necessarily. What we're seeing a lot of that, but not necessarily.
Yeah, the Nebraska Service Center and the Texas Service Center are perfectly capable of approving cases. All the cases moving to the NBC was the result of them having the local field offices having the bandwidth. It is possible for your case to be approved at the Nebraska Service Center. So, yeah.
I submitted my medicals also, and is there a possibility of getting it approved this quarter? Well, we just answered that question.
Yeah. Yeah.
It's a good question.
Yeah, it's mandamus and a lawsuit the same. Yes, that's a mandamus action is going to federal court and filing a complaint against the government saying the government's not doing their job. So yes.
So a mandamus is a type of a lawsuit.
Yeah.
And it's a word that says a writ of mandamus, meaning a request from the court to compel the government to do their job. So it's a unique type. You're not asking the court to evaluate the merits of the case. You're not asking the court to open the adjustment application and look at are all the forms complete? Do I have my medical? Did I do the filing fee? Is there any inadmissibility? No, they don't look at the merits of the case. This has nothing to do with the approvability of the case. It has to do with a simple question of the government has unreasonably delayed my case. I have a clear right of relief. The government has a duty to act. The government did not act, and I am damaged because of that, and therefore I'm asking the court to compel the government to do their job. That's what a mandamus is.
Okay.
And it's a lawsuit.
So, Perul Trivedi, what is your prediction for November 2022 visa bulletin? Well,
there has to be, okay, so do you have one, Brian? Because we haven't talked about that one. So that one's a good one.
Here's my prediction. It will come very soon. I have the feeling we could be talking about the November visa bulletin next week because they have been coming earlier and earlier. Very modest movement forward for EB2, and I guess perhaps EB3. I don't know why it's moving forward right now, and it doesn't seem like it has the bandwidth. But very modest movement for either of them. But ultimately, we're thinking it could be January before we see movement in EB2. So, yeah.
So mine would be similar to yours, Brian. I would say no movement in the final action date until January, and some movement in the dates for filing.
Yeah. Well, I think the dates for filing. I'll slow down on my rant about dates for filing, but if they have a bunch of new visas that must be approved in this year, and they don't have enough in their inventory to use all those visas, they have to move the dates for filing to take new cases sooner or later. This is a great question, and I think it really goes well with our topic. 18 months to 42 months.
Mark that change, and if you had screenshots of the 18 months and the 42 months, this is when the government says in the mandamus action, It's within reasonable processing time.
Yeah, it's whatever. When you're within our normal processing times, that's how long we normally take.
And that's when you tell Your Honor, the normal processing time is a number they grab right out of you know where.
Their ear, Sam. That's the one I use.
Okay, yes, because you're a very polite guy, and I'm afraid I may not be that polite here in a couple of minutes.
Okay.
Because it is not based on anything that is realistic or factual, and it's a game they play. And they need to be completely disregarded as a yardstick for anything whatsoever. But that's why, to answer your question.
That's why, I mean, yeah, we're seeing that, and that's kind of why, we're talking about this subject today. So, go ahead. I'll do it. Okay. YRG. My priority date is June 2014 in EB3. Should I look for a new job or wait it out? I did get my EAD AP expiring in August 2023.
Okay, so that's an excellent question that requires us to pause a little bit.
Yeah.
Because obviously, to remind everybody, you have an obligation to work for the green card employer. That's what you've promised. Now, you can go back to them later. And the question for this gentleman is 2014. I can tell this person that I don't see the 2014 becoming current within about a year to 2 years, in my opinion.
Yeah, the portability rules are there, so you can take advantage of them. You could take advantage, file a supplement J the day before you get a green card, and as long as their heads aren't blown by your supplement J, it's not a problem.
If you feel that hanging out where you at for 2 years plus is not in your best professional interest, and there are opportunities out there, reasonable opportunities within the same or similar job qualifications, the law is written for you to take advantage of it.
Yeah, that's basically talk to somebody to understand how the portability rules work. The reason why these portability rules, like H-1B portability rules or adjustment of status portability rules, they are there to basically make sure that people aren't changed to their employer, that they have freedom, that in the event of very long processing I-485s, for example.
Is it true that EB2 and EB3 will move in tandem with EB3 slight ahead? Heard this from a lot of folks. What's your take? I think it's a bunch of baloney, because they are completely independent from a number standpoint. Different applicants, different rules, and they have absolutely nothing to do with each other, with one another, except that you can interfile, jump between them, but that's it.
Yeah, I mean, so the difference between EB2 and EB3 for me is that all of the, that there's so many, EB3 gets their EB3 allocation, and they don't get overflow from, downflow from the EB1s, which get also upflow from EB4, EB5. Whereas EB3 just gets the benefit of cross-flow from other countries. EB2 gets unused EB1s. There's more that goes in the EB2 pot. Thereby, I think EB2 has to move faster.
Because EB3 priority date is retrogressed, and it's a trickle down from the top down. EB2 India will eat up all unused EB1, and will eat up all unused EB2.
Yeah.
And there will be nothing left on that available visas for EB3s from the trickle down, or the flow down, or the fall down, whatever you want to call it. And therefore, EB3 will only receive fall across from other countries unused, and that's substantially less.
I guess the only thing that can make EB3 move faster than EB2 is if they're, everybody just files for EB2, but basically that is self-correcting, because if people see the EB3 get ahead, they will move to EB3 to get that green card.
And we saw that before.
Yeah, exactly. Yeah. That one we skipped her.
When the dates will be current for February 2013? EB2. Sometime this year.
Yeah, that's only 8 months off current. I believe that.
I just joined this live. Sorry, it was already answered. My priority date is January 2015. Can I expect the date come current in India next 2 years?
Assuming it's EB2, I believe so. I mean, it made it to January 1st, 2015, as far as it's been, and it was close to January 2015. It's still close. It's technically for the month of September, still close to that. I think it's very possible.
Yep, take that one, Brian.
Sure, from Ajay Shah. My case finally moved from TSC to NBC. My PD is September 2012, so it's no longer current. Does this mean my case will not move to a field office, or will it still move? So we have seen RFEs from, coming from field offices for people without current priority dates. So I think it's still possible to move, and basically I don't think the government, maybe this is them anticipating movement in the priority dates. And the bottom line, I don't think the government is doing bad work if they basically make sure all the boxes are ticked for your case right now, and then they're just waiting for your priority date to become current.
I agree. Good evening. Thanks for the information provided. USCIS allocates visas by quarter to backlog countries, correct? India or EOI.
Yeah. Or end of year. So basically,
yes.
yeah.
No, yeah.
It's quarterly.
Quarterly.
Yeah.
Do we know rest of the world demand for quarter number one? We will not, even the government would not know until the end of quarter number one.
That's real crystal ball talk, yeah.
And that's January,
Yeah.
so you have the month of October,
so
November,
Q1,
December.
Yeah, that's Q1. Sorry, Sam.
No, that's okay.
Yeah,
Go
Q1
ahead.
of the fiscal year is what you said, October, November, December. So they won't know until
January 1st,
Yeah, it's the
where
earliest.
there's really a possibility to calculate, and the government doesn't calculate that quickly, but it could be probably for the January visa bulletin. By then they might have an ability to figure out the rest of the world and whether
or maybe
they need to-
February, because January, I don't know. They might have
for January visa bulletin for February.
Yeah, they might have a prediction, for January based upon what they see, because that'll get released in late December. They might have based upon what they see in October,
Yeah.
November, and December.
So if the rest of the world is substantially low, we don't. I mean, even the first quarter, you only get 25% because it's by quarter of the allocation for the year, and that allocation, that 25%, may not be enough to eat up the inventory. So you may not even see a movement in January, except for the dates for filing, but you may see things after that moving forward.
Yeah, it'll be really interesting to watch. I mean, I definitely, people ask, what are predictions? I predict it'll be an interesting one for November.
Prevailing wage determination and perm processing delay. Oh yes, priority date from previous employer, January 2016. What option if dates are current? Or should I go for an employer change?
So,
Well, if priority date is January 2016, my friend, you have plenty of time to get that perm certified before, in my opinion, you're current in either EB2 or EB3.
yeah, I mean, the bottom line is it takes about 7 months to get a prevailing wage for perm process right now, about 8 months to process the perm. That's 15 months. That's a little bit over a year. So yeah, I think it is possible to go for an employer change. Your worst case scenario, if visa bulletin predictions are way off and your priority date becomes current, as long as you don't burn the bridge with your prior employer and they're still willing to have you, you can go back and to file your green card through them.
The next one is a good question, Brian. Is there a period on how long can my wife stay outside the U.S. when her I-45 is pending? Or if USCIS can deny 485 if she stays outside above a particular period? She is derivative. Well, there is nothing to worry about for as long as you have, she's either on a valid H-4, she has a I-94 with a valid H-4, or she has an valid advanced parole that you're able to renew, because she is not a permanent resident, and she has no obligation to live permanently in the U.S. And the green card approval is, as we see here, can take forever. So for her, if she has business to attend to overseas, clearly there is no basis for them to harass you or her for her stay outside the country.
Yeah, I agree. Well, I think we've seen this question already, so I'm going to move to the next one.
Yes, please.
Priority date on transfer notice is wrong and printed as 20th October 2020, which was my downgrade date. How do I correct it?
That's a big mistake. That needs to be fixed.
I would agree with that. And typically, talk to the attorney. If you're assuming you had an attorney help with it, they can put in a service request. That being said, you can put in a service request too with USCIS for typographical error. And that's kind of it. I find that there sure are a lot of typos on, transfer notices and receipt notices, and oftentimes these things are fixed, in the final notice. But gee golly, it would be bad if it wasn't, so I don't think it hurts to put in a typographical error. If they think your party date is October 2020, well, I certainly hope they would figure out that was quick, because they'd be wondering if, presuming, you're from India, they'd be wondering, how the heck do I have your adjustment of status case?
Yes.
Yeah, assuming it's employment-based green card.
Prior date August 2012, EB2 India. When do you think it will be current? How do you know that my I-693 is updated to my case?
So
that's an excellent question.
Yeah.
You mailed it and you have a FedEx confirmation and they don't tell you other than that. And if it is not, you will get an RFE and hopefully you have a second copy. But with regard to when do we think it's going to be current? August 2012. Assuming EB2, I would say we're hoping clearly sometime this year.
That's just a couple months. That's 4 months off of current. I think, honestly, it's maybe Q2 even of this fiscal year. So, I'd start eyeballing that visa bulletin around January, February, March.
Yeah.
So my priority date is January 31st, 2018, but still at MVC. Why? That must be a typo. January 31st, 2018, unless you're from China, perhaps.
EPS and movie, we need a little bit more information to help you out.
Well, yes. Really, the devil's in the details. But if your priority date is
again, I don't know how delayed it is. Mandamus is a possibility.
I'm going to check the China dates. So, if it's EB2 China, for example, EB2 China is party date current is 8th of June 2019. So that could be somebody's case who's a legitimate question. And I think, this kind of points to the topic why we're talking about mandamus tonight. It's the government sometimes does things in a logical order. And people sometimes get green cards before other people. Now, I guess we can't expect approve every I-45 with a priority date of April 30th, 2012, and then to do the April 31st, then May 1st. It's kind of impractical. Yes. But again, it seems like they're really kind of far off the mark on that one.
I agree.
Yeah.
On the next question, look how many people have duplications. How many questions do we receive with people who have both EB2 and EB3 pending? Yeah. Any chance of fiscal year 2023? From May of 2015, I think you have a reasonable chance in EB2 for sure. Definitely, we don't feel that EB3 is realistic for 2015.
EB3 is just so far off. But all it takes is another global catastrophe, Sam. And
let's not hope for that.
Yeah, I'm going to touch wood on that one. Yeah.
Momo Lee, how to ensure cross-chargeability is applied to my case? Tier 2 or congressman did not help. Case is on hold. Well,
cross-chargeability. Oh, that's a great question when we don't get too much here.
Yeah, well, cross-chargeability, for everybody to know, is if your spouse, for example, from another country, and now you become current, and there's nobody's talking to you about it. Again, you try these things, and if you feel like you're running out of time, you just got to file something in court to tell the court that my case is not being attended to. I tried congressman, did not help. I tried this. I need to compel the government to act on my cross-chargeability.
Yeah, there's certain scenarios where I'd say clearly they've obviously applied cross-chargeability. For example, if you wouldn't be current based upon, if they shouldn't accept your case without the cross-chargeability, if you're, hypothetically, born in, India, and you have
spouse in Australia.
Yeah, you have a 2018 party date, but your spouse is born in Australia. If your party date would be current based upon your country of birth, and they took your case. If they don't, we've had cases before where somebody was clearly eligible for cross-chargeability, and you send that case to USCIS, and they send it right back to you saying your party date's current, and then you send it back to them, circle on the cover letter where you wrote, in giant text cross-chargeability, and they'll eventually take it back. So really, the devil's in the details.
Yes, I agree. But you have to be aggressive in pursuing that.
Yeah, if I'm sending out a case of cross-chargeability, I'm going to choose the biggest fonts that I find sensible, and I'm going to put it on the cover page. Do not reject cross-chargeability. Yes. Spouse's country of birth is X.
Yeah. October 22, 2020 filer. EB. Well, I like the name. October 22 filer. This is the kind of the new generation of filers. Remember those guys? They're stuck now, half of them.
Yeah, no, you're right, because historically there was, we were dealt with the 2007 filers for years. Yeah.
Yes. Oh, yes. EB3 priority date August 2013 had submitted medical reference in September 2021, but file moved to Texas Center after 2021 retrogression. A few days ago, file moved to National Visa Center. What to expect now? Priority date 2013, August, I say that they're definitely getting this case for a forward move future movement.
Well, I mean, but
EB3, right?
EB3, that's, a year and 4 months off of current. And we're sort of dismal on the view of EB3. So again, I would say the government can't do wrong in making sure that every box in your case is checked such that they can approve your case as soon as your priority date is current. What to expect now? Expect to wait until your priority date is current, and we'll cross our fingers for you that it's current earlier than we think.
All right. So Kumar Amit, priority date and perm processing delay.
We have seen that question, yeah.
Wow, good. How many times did I see the same question? Kumar is active. All right. With EAD and advanced processing time so high, how do people like me with priority date July 2014 really use the benefit of filing an adjustment of status?
A good question.
Yes. Well, ultimately you will get these benefits, but yes, it is going to take a little bit of time.
So for me, I would say the EAD processing times are a lot more palatable, and you get the benefit of a automatic EAD extensions right now, which are for a ridiculous period of time. I think it's like 540 days. I don't remember the exact. It's 500 some odd days. So that's good. I mean, the thing that really bothers me is the AP. They are taking a very, very long time to issue those.
I hate to encourage a mandamus action for an AP, but you just have to have a litigious mind.
Well, I think about,
especially traveling and seeing family. Now you're trapped here.
Well, I will give you that, but if you have a compelling reason, there's always, going to for the expedited AP request. If you have, a death in the family or something, you can get one of those to turn over pretty quick.
Your family have to die to be able to go back home?
Okay, you're right. You're
for crying out loud.
Well, I will give you that. I mean, and Sam, here's the problem with this. What's the alternative than using ask anybody how long it takes if you want to go to India, for example, how long it takes to get a consular appointment.
Especially if you are on EAD.
And I've heard problems, from my colleagues about China as well, getting appointments or getting visas approved there.
The good news is there is a lot of discussion right now about allowing H-1B stamping in the U.S.
Yeah.
So this is something used to happen, I'm going to go back 15 years ago. We were able to issue stamping in the U.S. For visas.
That recently?
15, maybe 20.
Yeah.
I don't know.
Yeah.
But a while back, we were able to get stamping here in the U.S. except for E2 visa stamping, and that was a wonderful system. And then they just gave it up, which was ridiculous. So I think they're talking about reinstating that right now, which is a wonderful thing.
That would be huge. I mean, it's really stressful for people to travel, not knowing when if they're going to get approved.
Getting a new H-1B stamp is a fantastic thing to do here, and it's a logical thing to do.
Yeah.
All right, so we're at 7:08. We're excited answering questions, so let's roll one more and we'll go from there.
Yeah, that was a duplicate one they had up. Okay. So let's ask this. We'll come full circle and come back to the topic at hand. Should one's priority date be current when the lawsuit is filed in order to get a favorable decision?
Yes, because there's the first criteria is that you have a clear right to relief, to the relief requested. And that's one of the writ of mandamus requirement listed in the 28 USC 1361 in the code. And therefore, it's very simple for the court, for the opposing counsel to say, Your Honor, there is not a clear right of relief. There is no visa available for this person. He should bring his claim when the visa is available. Yeah. And you've wasted your time and money. Yeah. With that, thank you so much, guys. Come back next week.